got that other program going. I'll be ready whenever you're set.
Perfect. Thank you, sir.
Hey, sir. Autumn Lee Philly.
Hi there. What was your name again, sir?
Autumn Lee Philly.
Thank you. All right. I want to confirm your address. Give me a moment. All right, sir, the state is alleging a total of 4 charges against you. 3 of them are felony allegations, and 1 of them is a misdemeanor allegation. The 3 felony charges are dangerous drug possession or use, drug paraphernalia possession or use, and theft under shoplifting, altering a UPC label. The misdemeanor violation is a shoplifting charge. Also, on those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for 2 hearings. The first one is a preliminary hearing regarding the felony allegations. The preliminary hearing is to determine if there is probable cause to charge you with the felonies. If probable cause is found, your case will bind over to the Gila County Superior Court. If probable cause is not found, then the case could dismiss. There is a possibility that the case could go in front of a grand jury prior to your court date, which is May 26th at 4:00 p.m.
Okay.
The best thing for you to do is to call the business day ahead of time. It's to find out if that hearing is still taking place, because you may not need to appear.
Okay.
Regarding the felony charge, the misdemeanor charge of theft shoplifting, I've scheduled you for an arraignment, and that date is on June 3rd at 9 o'clock.
Okay.
The arraignment is where you'll need to be prepared to plead either guilty, not guilty, or no contest to that misdemeanor allegation. Depending on how you plead will be what happens next with the court proceeding, and those options, as well as the penalty range, will be explained to you prior to giving your plea, so you'll be well informed on it. Your release conditions are: obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes or if you obtain an address.
Yes,
Do
sir.
not leave the state of Arizona without permission of the court. Do not contact the alleged victim in any manner, and do not go near the location of the alleged offense.
Yes, sir.
Do you understand those release conditions?
Yes, Your Honor.
Can you abide by those?
Yes, I can.
And you'll show up to court on June 3rd,
Absolutely.
and then you'll show up to court again on May 26th prior to that June 3rd, unless you're otherwise notified?
Correct.
All right, I'll release you on your own recognizance with those promises. Do you have any questions?
No, sir.
Okay, that's all I have for you.
Thank you very much.
You're welcome.
Judge,
Yes.
next subject's a little slow, so just make sure you're explaining everything carefully.
Okay.
Ma'am, over here. Step right up here and state your full name to the judge.
Hello, Your Honor.
Hi there.
My name is Kelly Ann Steinmetz. You want me to spell the last name?
No, hang on one second.
Okay.
All right, the state is alleging one charge against you. It's assault found under the domestic violence statute. On that charge, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for an arraignment on the 27th of May. That'll be at 9 o'clock in the morning, and that's where you'll need to be prepared to plead either guilty, not guilty, or no contest to that charge on that date. Depending on how you plead will be what happens next with the court proceeding. All of those options, as well as the penalty range, will be explained to you on the next court date prior to you giving your plea, so you'll be well informed. Do you understand that so far?
Yes, I do.
All right. Your release conditions are as follows. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if your address changes. Do not leave the state of Arizona without permission of the court.
All
Do
right.
not, pardon me?
Yes, sir.
Okay. And then these other ones are going to be a little tough on you, and I'm going to be I'll talk to you about them shortly.
Okay.
Do not have any contact with the alleged victim in any manner. I'm not going to allow you to talk to the alleged victim, okay?
All right.
I'm also not allowing you to go back to the residence except with the police to be able to collect some personal belongings. So you're going to have to stay somewhere else for a short time. This is not a permanent order, but it is for a while. And the reason why I'm doing that, ma'am, is because this is your second domestic violence charge. So this is an allegation. You're not convicted. But if you have a third or subsequent one in 84 months, it could become a felony. So you got to be careful, okay? So you have
I understand.
you have the prior one that I looked at and saw, and then you have this one. This is only an allegation, but I don't want to risk having you do any interactions with the alleged victim in the case until we get you seen here, okay?
I appreciate that.
All right, and then the final release condition is I'm going to order you to pretrial services. So what that means is I'm going to provide you a name and phone number to the probation department. You're not on probation, but you are on release services. Their job is to make sure that you're abiding by these release conditions, and you'll have to check in with them, and they'll tell you what those requirements are, so you'll get the name and phone number in your paperwork. Immediately upon your release, you need to contact them. They probably are going to want to know where you're going to go to, know how to contact you, since you're not allowed to go back to the house except with police to get some personal belongings. You understand all that?
Yes, I do.
All right. Can you abide by those release conditions?
Yes, sir, I can.
And you'll show up to court as ordered?
Yes, I will.
All right. I'll release you on your own recognizance then. Do you have any questions?
Thank you for your time.
You're welcome. Have a good day.
You too.
Want to step up here? State your full name to the judge, sir.
Liam Patrick Sullivan.
Okay. All right, sir. I want to confirm your address. All right, the state is alleging one charge against you, and that is organized retail theft. That is a felony allegation that you have the right to remain silent, right to counsel, and right to trial on. I've scheduled you for a preliminary hearing on the 26th of May. The preliminary hearing is to determine if there's probable cause to charge you with that felony allegation, not convict you, only to charge. If probable cause is found, your case will bind over to the Gila County Superior Court. If probable cause is not found, that charge could reduce or dismiss. There is a possibility that the case could go in front of a grand jury prior to that date. If that occurs, you'll be notified of that. The best thing for you to do is to call a business day ahead of time to see if you still need to appear or not. Okay?
Yes, sir.
All right. Your release conditions are as follows. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if your address changes. Do not leave the state of Arizona without permission of the court. Do not contact the alleged victims and do not go near the location of the alleged offense. Do you understand those release conditions?
Yes, sir.
Will you abide by those release conditions?
Yes, sir.
And you'll show up to court as ordered unless you're notified?
Yes, sir.
Okay, I'll release you on your own recognizance. Do you have any questions?
No, sir.
Okay, that's all I got.
Thank you, sir.
Civil Affairs, state your full name to the judge.
Hayden Alexander Spichala.
All right. All right, sir. The state's alleging one charge against you. It's a felony allegation of organized retail theft. You have the right to remain silent, right to counsel, and right to trial. I've scheduled you for a preliminary hearing on the 26th of May at 4:00 p.m. That's to determine if there's probable cause. You'll get a copy of this, so you won't have to remember it, but so you'll see the court date. The preliminary hearing is to determine if there's probable cause to charge you with that felony allegation, not convict you. If there is probable cause, the case will bind over to the Gila County Superior Court. If there's not probable cause, then the case could reduce or be dismissed. There is also a possibility that the case could go in front of a grand jury prior to that date, which would therefore mean you do not need to appear. Best thing for you to do is to call a business day ahead of time to see if the hearing is still proceeding, so you know whether to show up or not. Your release conditions are obey all orders of the court, do not commit any crimes, notify the court immediately. If your address changes, do not leave the state of Arizona without permission of the court, do not contact the alleged victim, and do not go near the location of the alleged offense. Do you understand those release conditions? You get a record?
Yes, sir.
All right, can you abide by those?
Sir, may I ask a question?
Yes.
They had me leave my car in the parking lot, and they told me I could come back and get it. Is that going to be okay?
Yes. So you can go and retrieve your property, but after that, once you vacate the property, then not to return to the Walmarts, okay?
Yes, sir.
All right, any other questions in that?
No, sir.
You can abide by those release conditions,
Yes, sir.
and you'll show up to court as ordered?
Yes, sir.
All right, I'll release you on your own recognizance. Do you have any other questions?
No, sir.
Okay, that's all I've got.
Thank you, sir.
Thank you. Perfect timing. And I got that court date from Andrew since we forgot to get it.
I'm sorry.
That's all right.
Civil Affairs, state your full name to the judge.
Dylan Reese Goss. We met yesterday.
We did. Well, how come?
I came into the courtship about that, the roommate.
Okay, yeah, all right. Let me confirm your address. All right, so there was a warrant for your failure to appear on case number 2024 CM 12140. That was a charge of domestic violence, disorderly conduct from a 2024 case.
Okay.
So when you failed to appear, the warrant issued, and that's what you're here for. So there's two things I'm going to do is I'm going to hold the arraignment now with you by video.
Okay.
To be able to do that, I need your permission waiving your personal appearance. Instead of you having and coming on another court date and standing personally in front of me, we can do this by video as long as you waive your personal appearance. Do you have your consent?
Sure. Yeah.
Okay.
Yeah, my consent.
All right.
I trust you.
Okay, well, the only thing you're doing is waiving your personal appearance. I'll send you a form to sign regarding that, okay?
Okay.
All right, so the charge is disorderly conduct under domestic violence. That is a class 1 misdemeanor that is punishable with a maximum fine of $2,500, a maximum term of jail of 6 months, and or a maximum term of probation at 3 years. Your options are to plead guilty, not guilty, or no contest. There is a mandatory minimum penalty. The mandatory minimum penalty, because of the domestic violence statute, is a $50 address confidentiality fund fee. Additionally, a $50 domestic violence fund fee. And finally, a mandatory domestic violence counseling.
Okay.
Again, your options are to plead guilty, not guilty, or no contest. The difference between a guilty and a no contest plea is the following. If you plead guilty, you're admitting to the crime, that you committed the crime. If you plead no contest, you're not admitting or denying, but you're accepting a conviction. Both guilty and no contest show on your criminal history as a conviction. You also can plead not guilty. If you plead not guilty, I'll schedule you for a pre-trial conference. That is where you'll meet with the prosecutor, have a discussion with the prosecutor. They may provide you information from the police report or even the police report to review. At the conclusion of that pre-trial conference, the following options will be available to you. Number 1, the case could be dismissed. Number 2, the case could enter a plea agreement that all parties agree on. Number 3, the case could proceed to a trial. Number 4, the case could be a change of plea where you end up changing your mind from not guilty to guilty if that's possible, or it could be continued for further information gathering. Do you understand those options?
I understand those options, yes.
All right. You also have the right to an attorney. As of now, this case does not have any jail time being sought by the prosecutor. If that changes, your rights will change, but as of now, there's no jail time. So you might be asking yourself, why am I in jail then? Well, the reason why you're in jail is because you didn't show up for the appearances. It has nothing to do with the sentencing of the case. Does that make sense?
Yes, sir.
All right. So your options for an attorney are to hire an attorney yourself, to waive the presence of an attorney, or to ask the court for a court-appointed attorney. If you ask the court for a court-appointed attorney, there's 2 requirements. Number 1, you must not be able to afford an attorney, so you must financially qualify for one, okay? Right. So number 2, there must be good cause. One example of good cause is jail time, but I informed you there's not jail time as far as any sentencing that's being, if that changes, your rights will change. Another good cause would be a mental disability, and there's some other ones. So if you're wishing for a court-appointed attorney, you tell me why you think you need one, and I'll let you know if that cause is good or not, okay? Or if you wish to waive the presence of an attorney, or you can hire one at your own expense. You understand that?
Yes.
Okay. Regarding your attorney decision, do you wish to waive the presence of an attorney, hire an attorney at your own expense, or provide the court good cause for a court-appointed attorney?
Appoint a courted attorney.
Okay. So I would like to hear from you on the cause for that court-appointed attorney.
Well, I cannot afford an attorney myself.
So sure. let's presume that you qualify for that. Now then, give me the other parts.
Okay. The other part would be I am mentally ill. I have a mental illness, schizophrenia. So.
Okay. So with that diagnosis, has that been medically diagnosed?
Yes, sir.
Okay. And with that diagnosis, does it affect your ability to make decisions?
Sometimes, yes.
Do you have a driver's license?
I do not have a driver's license. No, I cannot drive.
Is that because of the disability?
Yes.
Okay.
I can get too distracted.
Okay. With that, do you have the ability to produce evidence to the court that shows that diagnosis from your medical practitioner?
Yes, sir. Yes,
okay. So what I'm going to do is I'm going to presume that you're going to provide that to the court, and I'm going to enter a not guilty plea for you. Okay. And right. What I need from you still is that document that is diagnosed with that disability. Okay. If we do not receive that, then you're not going to have an attorney assigned. All right.
All right.
So so you have to follow through. Is there any issue with you following through with that?
Not a problem. I can get a hold of my case manager after today.
Okay, let them know what's happening, and then they'll know to either draft you something or produce something that they've already drafted.
Okay.
All right, so let me review your release conditions with you. Obey all orders of the court. Do not commit any crimes. Notify the court immediately of any address change. Do not leave the state of Arizona without permission of the court. Do not contact the alleged victim with any unwanted contact. Your court date is scheduled for the 22nd of June at 9 o'clock a.m.
Okay.
Now, you failed to appear at the last court date. So tell me why you shouldn't sit in jail for over a month to hold you for this court date.
During that time, I was homeless. I could not get anywhere, do anything. Yeah, and I apologize for that. I was going through a difficult time, and I was not able to appear at the court dates. I didn't have transportation. I didn't have any steady place to stay. But now I do. So this can all be taken care of. I promise.
Okay, well, one of the concerns is that you have a difficult time again, and you just feel that it's not important to let the court know, because that's what you just explained. So these are orders that you need to be here. When you violate the orders, the warrants go out. So I'm going to give you the benefit of the doubt this time, and I'm going to release you. But if you don't appear on this court date and we warrant your arrest, most likely when you get arrested, you'll sit there until the next court date and until the case is adjudicated, however that is, because of your broken promises, plural, not broken promise. So you got an opportunity here, okay?
Okay, thank you.
We're gonna assign your attorney. You'll get a copy of who that attorney is and their phone number. That'll be assigned to the case, but we need that other document from you still, okay?
Okay.
All right.
You got it, sir. Yes, sir.
Do you have any questions about anything that we spoke of?
No, sir.
Okay, and you'll be released here shortly.
All right, thank you.
Yeah. Stop record. All right. Is that it?
Yeah, yes, sir.
Okay, we'll get it sent over for you shortly.
You got it. Thank you, sir.
Yeah.